Hey, friends, and welcome to Facts, Opinion, and Real Talk. I'm your host, Heather Honey, and we are on day 3 of verdict watch for the Karen Reed trial. And we did earlier have the jurors have a question, but let's double check and make sure that I am streaming to YouTube. Okay, and I am. Good deal. All right. Okay, so I'm going to pull up and we're going to listen as Bev goes over the questions that the jurors had. So, give me just a second. Yeah. Well, I don't like that one either. There we go. We'll get there eventually. Okay. Okay. Has she? Oh, she had already read the questions there. Bear with me. This is what live streaming's all about. Okay. This is after they had already. Let's see here. I'm trying to find where they originally brought in the questions, and Bev went over them. And then they had a sidebar. Maybe that was it. Okay, yeah, I think she called them up there first to discuss it because we were dying to know what they were saying, what they were thinking. Okay, so Yannetti and Lacey are sitting there discussing. Bob, let's me. Jackson is writing something down. Little is on standby, and Karen is in the discussion with Alessi and Yannetti. And what's great about Karen is she is highly involved in her case, as she should be. I saw in Travis Rudolph, he would go up to when they would have a sidebar with his attorneys. Thought that was fantastic because it's your life. You should be out there. You should be knowing everything that's going on. Yes, they're being paid, but well, in this case, they're now gone pro bono, but still, you should be just as involved in your case as your attorney. What if your attorney's giving you bad advice? Or what if, your attorney needs help? Like, your attorney might not have, or you might not have access to 5 different attorneys and some interns. You just never know. So, this is why it's also important to know your rights, to get involved, to know about the law and the court, because you never know when you might be Karen Reed or you may be in some kind of, I don't know, instant where this may happen. Okay, let me go ahead and fast forward this. Okay.
Who appeared in the communication was in fact Karen Reed. So think about.
I don't know why I'm missing the question part, because this is where they're standing, they're excited. Um, I think my mouse is going too much.
3 questions from the jury.
Okay, here we go.
The first one is, they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language.
Okay, and this is what we talked about yesterday, where I brought up the verdict slips and talked about how on count 2, that was the one that had like the main charge, and then it had all these lesser charges, and it didn't really give a definitive, or it didn't have definitive instructions for the jurors, written instructions as to, do you check one, and then you check 1, 2, or 3 of these, or do you check this and stop? Or, it was very confusing. And so this is what one of the questions that the jurors had, which I thought was fantastic, because this I hope it just knocks her ego down just a little bit, because this is the motion that the defense wanted to bring up to the juror. They filed the motion to clarify these instructions to help the jurors. And it was a problem last time. That is why that counts 1 and 2 were also hung jury, because they weren't filled out, because the jurors didn't know what to do. And she didn't take the time to ask them, did they have any questions? Anyways, so, but yeah, so I'm really glad she had that question, or they had that question. And they also didn't have a foreman to block them from asking questions. Because if you remember that interview with Aiden Turtleboy and the juror Ronnie, he stated they had a question about that, but that their foreman would not allow them to ask. He said, no, we're not asking that question. So I'm very thankful that this is a jury that, if they're not sure, they're not just going to mark something, because guess what? They're taking this very, very seriously, that this is Karen Reed's life. This is a human being's life that they have in their hands. All right, let's continue.
I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after? Give you 20 minutes.
Thank you, Your Honor.
Oh, how kind of her. She gave him an extra 5 minutes. Okay. I'm sorry. I'm so over this whole thing. I can imagine how I feel versus what Karen Reed is feeling. Her attorneys, her family, everybody that is boots on the ground. I know they're exhausted. I was exhausted I slept a lot last night into this morning. It's just I'm emotionally and physically and mentally drained. So I'm ready for this to be over, and and hopefully it's going to be a not guilty on all three. Based on the questions, it looks like they are thinking about the OUI, which is like DUI in some states. They're not thinking about any of the manslaughter or the murder, so that's good. But with the only thing with the OUI is Massachusetts, they take it very, very seriously, which it is good. But I mean, if she's found guilty of the OUI, then there's possibility she could get 2 years of jail time. And knowing Bev, she would probably do that. I'm praying that's not what happens. This needs to be done and over with. All right, let me fast forward to where they came back to talk to her.
Well, yesterday I said they have to be red-handed.
Oh, Mr. and Ms. Reed, they are precious. And bless them for having, they are Karen's support system. And I can't imagine. I cannot imagine what all they've gone through. Okay. That's them working. Right, 20 minutes. Okay, look how many people are out there. That is amazing. It was nowhere this many people when I was there. But I was there like, what, second week, third week? So glad to see so many people.
You have the evidence. It's your.
Okay, now they're going to be going over what their ideas on to answer the jury's questions. And of course, they're going to argue that. Let me find.
All right. So I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
And what kills me is when she has these suggestions,
Brennan?
she says something that sounds great, but then she doesn't say that to the jurors, which
And why is that?
irritates me.
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
Okay, so if I've skipped it or didn't make it clear, the 3 questions were, okay, if they are to consider the OUI, what would be the time frame? Would it be 12:45 or would it be, I think it was like 5:15? The second question was about the juror slip, about if they find her on, they called it a subset, I think, or sublet, like a lesser charge. If they found her guilty of, I think they numbered 5. Would she still be counted as guilty for the main charge, which would be the manslaughter? And the answer is no. But see, because those forms are not clear, they're about as clear as mud. They ask the questions. Again, that's why I'm so glad they asked questions. And then the last question was, I keep forgetting this one because I get so stuck on that that second one. Let's see. Let me see if I can find it right quick. Let's see. Okay. Oh yeah, the video clips. Okay, so are the video clips of Karen's interviews considered evidence? If so, how can we consider them? So in other words, they want to know like the weight. How should it be a big issue? Should it not? And Bev said she didn't feel comfortable listing a time, and the defense agreed. Nobody wants to list a time and that was the part about the fact finders, that they're leaving it up to the jury. And then of course Hank is going to argue because he's defeated, but I have to give him this. At least he's going down swinging.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
Poor AJ. He sounds like he's got a cold and he's worn out. I just want to give them all a hug.
All right. So I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Do it anyway. I heard hot mic. So somebody said, do it anyway. They're probably saying she's going to do it anyways. You're right. See, with the headphones, well, I know a lot of you who don't do YouTube.
What's the Commonwealth's position?
We have a different perspective
Hold on.
on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been interviewed substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws and keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
Bless him. I want to give him a tissue and a cough drop. Ew. I can imagine touching those papers after she's licked them with her fingers. My gosh. Sure as I move this, I'll go past it. Oh, but what I was saying about the headphones was it helps for us to hear. Like I was having an echo a few days ago, which I figured what that was. But again, I wouldn't have known y'all were hearing the echo had I not had the headphones on. Also, it helps with editing so you can hear every little thing, especially if you need to split a screen or split a video that you took and kind of take something out that didn't sound just right, or if you said too many times or things like that. So it's good for editing to have these. So it's not just to try to look, oh, I'm cool kind of thing. But anyways, I'm trying to keep you entertained while they're writing notes and everything. And I keep checking my phone because, again, this has been probably, I don't know, 30 minutes to an hour ago. So I'm still trying to keep a check on any verdict because I don't know. I'm expecting after lunch, and I think they're going to be meeting back after lunch. I think Bev said, what time did she say? 12:30, I think, which would be 1:30 my time. I could be wrong. I don't know. I'm kind of like, it's hard to focus today. Got a lot going on outside of YouTube world. And then this has been a big part of my life too. And it coming to an end, it's weird. I don't know. I think it's going to be a surreal feeling that we're finally, we're finally here.
Right. So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word if any.
I understand.
Because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, a complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to
The
the
objection's
third
noted.
one.
I mean, she's not going to do what he asked.
Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says.
Okay, I'm going to pause this just a second. I'm looking at Twitter and, okay, the judge said to be back at 1:30, which it is their time, 12:30 my time. So Sue O'Connell on Twitter is saying some of the defense team is here, some of Karen's family, prosecution on their way, some of O'Keefe family and friends arrive. Okay, so we don't know if this is going to be, y'all can, what about lunch, or if this is going to be, I don't know. We're going to see. So I may need to stop here. And I'm keeping an eye on law and crime. Okay, they're back in the courtroom. So let me get us back there.
Something along the lines of no.
I'll see you at sidebar so we don't do that.
Okay, so they're at sidebar. Come on. See, the courtroom's not even filled. When they get a call or they're told they have 10 minutes to be there and then they got to go. Okay, let's see what's going on.
Jim, can I have that question, please? Thank
Oh.
you. All right. So as counsel knows,
Shit, we got another question, I think.
we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
You need to tell them why you can't answer.
I agree. You can't ignore your question.
Who said that to ignore them? I don't believe
I
that.
think it is apropos.
I think that's why AJ just said that on record.
When that question came in, literally before the court had answered the other 3 note card questions, I think that it would be appropriate to send a quick note just asking them, given the fact that there's been clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question.
Exactly. They need to know the law.
I see it a little bit different.
Why is the judge telling us no?
What are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point.
She
It may be
disagrees
something
with him
later. The
all
way
the
the
time.
question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah. I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to
He
say,
didn't
because
ask
it's true, it's
for
the
a
law,
back and forth.
that this is not a question I can answer.
Did he?
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question.
Exactly.
Court
You
absolutely
can, but
answer
with
it. I
law.
would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other
Exactly.
steps that can be taken to perhaps prevent that.
Whatever
do you
whatever
say?
those steps
Bullshit.
are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Mr. Yannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, John?
1 minute.
How about 1 minute? You guys are 10 minutes late.
We do it 1 minute. Thank you.
You know, a life is on the line, but we're going to call you out because you were 10 minutes late. I'm trying not to cuss. Maybe I should take my journal and write in it while we're sitting here. See how involved Karen is? Love it. Because honestly, I would not want a group of people discussing my life and I not have any kind of say. I would want to be just as involved as they are. And somebody on Twitter, I think, had made a comment this been weeks ago, and they were like, "Look at like Karen was being nosy."
Tweak with the court's language. I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer. For
No,
the reasons I
you-
stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict. And that's exactly what you would be asking me to endorse.
I
What's the
don't even know
Commonwealth's
why we're
position
sitting
on
here
the
because she's going to
proposed-
do whatever
I
she wants to
agree
do.
with the first suggestion.
I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects this read's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer.
at
That
this
does
time,
the same
at
thing.
least
Is there an
if the court-
objection? I understand, Mr.
if the court
Jackson.
could add the clause at this time.
Is there an objection to me putting, this is a theoretical question, not a question I can answer?
No objection.
She's lying to the jury. She could answer that with case law or what, not case law, excuse me, with what the law states. She's not doing it. Back and forth.
That is over
It's
our
called
objection.
communication.
don't
I understand.
think I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I think
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't
Is
tell
that-
you to ignore anything, Your Honor.
all right, we are all set. So let's send this in, please.
I'm glad he gets that back in because I know I can't imagine Alan Jackson saying, "Oh, just ignore that." She is some bullshit. That's all I got to say about her. God, she drives me nuts. Okay, let me try to go back and find where we were. Cause did I write down the time? No. But anyways, oh God, I can't stand y'all. I can't with her. I'm so ready to go. Okay, so we're gonna go back to where they're talking about the jury's questions, those first 3 original questions, and then we'll jump back to that.
Offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Okay, so he is giving her directions as to
Right, after
how
the words
the defense would like the verdict slip. And here's a little tidbit for those that haven't been like really keeping up. When they submitted the motion to clarify these, they actually sent in as an exhibit an updated juror form or verdict form, excuse me. No, denied. So what do we do? We're wasting more time, Beverly Canoni, because you didn't listen to them in the first place. Biased. And I mean, I know that the judge is supposed to be non-biased either way, to either side, but come on. I mean, every defendant is supposed to get a fair trial. And none of this has been fair. None has been fair. And it has been like that ever since back in the pre-trial motions of trial 1, where the defense asked her to recuse herself because there was information out on the web through Venmo that she may have ties to some of the witnesses. And anybody with morals should know. And yeah, I said that. Anybody with no morals should know if there's just a what was it, scintilla of amount that you may be linked or know somebody or just even know somebody's name in the case, you need to be out. You do not need to have any business with the case. But anyways, so I don't know what she's going to do after this. There are rumors that she may retire. If she does, then you know there's some shady shit going down in Norfolk County. All right, let's get back to it. Sorry.
stop and sign the verdict slip.
Yep.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan.
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think with the edits, this proposed instruction explains it.
All right. Would
I
I,
don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language that can be used. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it. That
All
would
right,
be-
so you're waiving it?
We're waiving it.
Okay,
Yes,
all
thank you.
right. I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can. And we'll make copies, so we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you. Ron.
Okay, we know that, I'll just go ahead and skip back to where we were, because we know that they go over, and so then they submit the updated instructions that should have already been done because the defense requested it, but oh no, she won't allow it. The instructions on the verdict form are very clear, and they've always been this way. Who cares? Just because it's been that way for so many years, it doesn't mean it's right, and it doesn't mean that it's good. Okay. Okay. I just want to go back and rewatch that part about this other jury question. And I'm going to say her statement about them being late, that would be argumentative.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that.
I hate not being able to control this like I want
Can't
to.
ignore it. Can't ignore.
I want to know who said couldn't ignore it, because I really doubt someone on the defense team said, oh, just ignore it. I really doubt it.
We received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not to ignore it. I agree, we can't ignore it to your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our...
Okay, and this is the part, what they're talking about is she's just saying, I'm going to tell them I can answer. Okay, well, this was like in the first trial, the jurors had asked for a report by the CERT team when they got there to investigate where John O'Keefe was found. Well, guess what? There wasn't a report done by the CERT team. So instead of saying to the jurors, the CERT team did not do a report, period. She says, I'm not going to give you a report. I'm not going to get, or I can't give that to you. Or, yeah, something to that effect. She didn't let the jurors know that there wasn't a report. So I feel like that should have been an appellate issue. Not that I'm an appellate attorney, but I am a layperson and I could be a juror. And I'm telling you what I'm thinking. I would want to know everything. Just like they need to know that the FBI hired ARCA. The FBI hired ARCA, and they were also, and probably still are, investigating the Norfolk District Attorney's Office along with the Massachusetts State Police. Now, with that being said, back to this little back and forth between Alan Jackson and Bev. That's the problem. The jury, they don't deal with this every day. They don't know the law. They don't. Nobody, I mean, you can only know the law to a certain extent based on your own previous experiences. But overall, these people they don't know every little statute and they don't know it all. And that's okay. But that's the problem about being a juror, having to make these decisions. You don't have a book that says, okay, let's look up what the law says. And maybe that's something that we should start putting in these juror deliberations room. How about law book? I mean, I know that would be a lot of stuff, but if it was done in an organized way, like let Bob Alessi organize it, then, they could look it up and say, well, the law says this. And then they wouldn't have to do this back and forth with her. But her saying, I can't tell you, yes, you can. You can at least say what the law is. Now, you can say, I can't advise you what to do, but the law says da 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 da. And that would work because she's being honest and transparent. This, she's acting like, I can't tell you. Sorry. Hands off of that. It's not right. So anyways, all right, let's get back to it.
The options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those two counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature. It's hypothetical. It's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this.
And that's another thing. I mean, she started out, I can't tell you how many times she started, she was a public defender. She was a defense attorney. And she acts like this. You know why she's doing this. We all know why she's doing it. I don't even have to say it.
I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
Why can't you have a back and forth with them? Why? A person's life is on the line. Why wouldn't you do anything for somebody? Wouldn't that be the fair thing to do? Not only for their jurors, so they can make the right decision and leave knowing that they made the right decision. Or, well, let's just, hope for the best. It's just ridiculous.
Well, I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever you
I'm
say,
sure there are.
I think the first step down the wrong path.
Okay, Bev, what are they? Let's talk about them right now. What are the other steps to prevent that from happening? And when that was a problem last time, how come these steps weren't brought up? Why is it brought up this time? Oh, you had time to think about it? Think about and read all how everybody was mad because you didn't do the right thing? And I'm not talking about Devers' right thing. I'm talking about the real right thing to do.
is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
1 minute.
How about 1 minute? You guys are 10 minutes.
Who told her 1 minute? Because I heard that first. I bet it was Jim. Jim probably said, we have 1 minute. And again, why the rush? I mean, Karen's life is on the line. I'm telling you what, I would pitch a fit and they would have to probably, I don't know, carry me out, because if she sat there and say, you can have a minute, I'd be like, Judge, this is my life. We're not going to take a minute. We're going to take as much time as we need to think this through. It doesn't work that way. Because we're in Bev's court.
It's late.
We do it 1 minute. Thank you.
Okay. So they're thinking, again, Karen is right in there. I love it. And I mean, if you're ever in this situation, for the love of everything that's good, please don't just sit back and let them do the talking. You need to be just as involved. Not only for decision making, but you need to know what the law is in your state, in your county. You need to be aware. Knowledge is power. And that's what Karen is showing right now. Knowledge is power.
Just with a very slight tweak with the court's language, I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question.
Okay. This is what we have dealt with for 2 years, folks. Her being an ass to Jackson. And then, oh, Commonwealth, what do you say? Well, he wasn't going to say nothing until you asked him or offered. And you shouldn't have said nothing. And then he probably sat there and not objected. Tired of her guiding the Commonwealth on what to do. I'm just over it. Can you tell I'm over it? Because I can feel I am totally over this. I'm over her. I'm over the Commonwealth. Let's get this shit over with. And just not guilty on all three. Jeez.
And I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict. And that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that.
And another thing that is great, and also so you'll be like, why does he keep talking? Why aren't he letting her go? Okay, if for some reason, let's say worst case scenario, which we don't want to do that, hung jury, and we got to do this all over again. Karen can appeal, and these are statements to back up her appeal. We tried to do this. We tried to do that. So that's why he's getting all this on the record, especially the part about I didn't say ignore what the juror said or the juror's note, because we don't know what was said on that sidebar. And then there she does gets up there and said, oh, well, this is said and this is said. But she can't seem to say exactly anything that was said. Like when they talk about, let's tell the jury this, they bring the juries in and then she says something else, or she leaves a bunch of stuff out, just like in one of the instructions during the trial. Anyways, I need to quit griping and play this and calm down.
It doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr.
It's important
Jackson.
to add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't
Is
tell
that-
you to ignore anything, Your Honor.
all right, we are all set. So let's send this in.
Gosh, she drives me nuts. She just ignored what he was saying and walks on because she thinks she's going to get that last word in. But I am so glad. And the court reporter better have gotten him saying, I didn't say to ignore it. Anyways, I wonder who said it.
All right.
All right. So let me just fast forward and see where we're at. Okay. So we still have the only fan up. So, and I've checked and I don't see anything. I don't see anything stating. So right now I want to pull up those verdict slips that I talked about yesterday. And that was the main concern about, well, what the jurors are having questions so that you can see what a problem this is. And there needs to be some changes made in these forms. Hint, hint, Massachusetts and Norfolk County. And they need to get updated. And they need to get updated like 10 years ago. Updated. So let's go ahead and put this on the stage. All right. So this is the first verdict slip number 1, which has the account 1 on it. Verdict slip, again, it has the case number, offense 001, murder in the second degree. In the above entitled case, we, the jurors, say that the defendant is, and then hopefully they will check not guilty. This one is so easy. It's either guilty or not guilty, and it's unanimous. The foreperson signs it and then dates it. So you're done with that. And then we're going to go to 2. All right. This is the one that's a problem. And this is the one, like I was telling you yesterday, this would be like taking a test for me. Like I would do page 1, and let me go ahead and go to page 3, to account 3. See, it's not much. So count 3, count 3 is leaving the scene of an accident resulting in death. In the above entitled case, we, the jurors, say that the defendant is not guilty, guilty. Same thing, easy, just check one of them, date it, foreperson signs that it's a unanimous decision among all 12 members of the jury. That page 2, that, first of all, if you got ADD, that page is not made for us. It is made for, I don't know what, but it's not made for us. It is made for, let me go back to that page 2. I mean, again, so we've got, let me put this. You know what? Bear with me. Okay. All right. In the above entitled case, okay, this says offense to manslaughter while operating a motor vehicle under the influence of liquor. In the above entitled case, we, the jury, say that the defendant is. Now, here we go. We've got there's five, I'm going to say choices because my first thing would be choices, but she did give the instruction of work your way from the top to the bottom. But she also said, and given her verbal or oral instructions, those supersede the written instructions, which if you can't have a transcript, you're not even going to remember what she said in there because you're going to be ready to get in there to deliberate. Okay. So number one, not guilty of the offense charged or any lesser included offense. So, like taking the test, I would have to skip that because I need to read what the others say. Number two, guilty of offenses charged. Manslaughter while operating a motor vehicle under the influence of liquor. Then it has check one or both of the following. Manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08% or greater. Okay, number two is the same as that second or that where you check one or both. Why would you? Do you see how that's a problem? I would have to reread that for every little word to make sure it was the same thing. And then it says and or. I don't understand why that's listed twice by the number two and then like a little subsection under that. I say that says and or. It should say just and. I would think, but who am I? Oh, I'm just a layperson trying to read a verdict slip I've never seen in my life until the day to deliberate. Okay, number three, guilty of lesser included offense, involuntary manslaughter. These are terrible. Number four, guilty of lesser included offense. Okay, how? Oh, that was manslaughter while operating a vehicle. Okay, my bad. Okay, so guilty of lesser offense, just involuntary manslaughter. That would be leaving off the while operating a motor vehicle under the influence of liquor. Okay, number four, guilty of lesser included offense, motor vehicle homicide, which is felony, OUI, liquor, and negligence. Check one or both of the following: motor vehicle homicide by operating a motor vehicle under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08% or greater. I guess by the numbers I wouldn't even know what to put. A check mark, an X, or this, but not this one. Oh Lord, my brain is all over the place over this. It tears me up. Okay, and then the fifth one, guilty of lesser included offense, operating under the influence of liquor. Check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08% or greater. And then they would, again, the foreperson would sign, date, and it says this is a unanimous decision. Well, that's a lot to read. I bet you they're hung up on this page. And then with the questions, it makes, I think they are leading toward the OUI. And but that's a big deal in Massachusetts. I mean, it's a big deal everywhere, but it's not a slap on the wrist. She could get up to 2.5 years. And knowing Bev, she would probably do that. And I don't want that. I'm ready for Karen to go home. Like home, like not have to come back to court, not have to come back to court, not have to deal with this. So, but anyways, so that's the deal with the verdict slips. And I don't know, 1 minute I feel fine, and the next minute I don't know if I'm anxious. I think I'm just tired and I'm ready to be over with. I can't just shut it off. I'm constantly checking all the channels I watch. Shout out to my friends at Resistant to Silence. They are boots on the ground there in Dedham. And also to the Alternate Corner. And he is from Wales. That's Dylan's channel. And also to shout out to the y'all, my brain is just done for the day, and it's only 1:12 here. Calling All Beings, they're friends of mine as well. So be sure to follow them, and I'll put their links in the lives. And I'm probably not going to update all my stuff until tomorrow, because like I said, I'm tired, and I can't imagine how everybody else feels. Let's see what the other channels are doing. Let's see here. Let's check out Dylan's channel.
Yeah.
Hope they don't care that I'm sharing
I
their
know.
channel.
I wish I was there as well. Oh, this
Yeah.
stream's been going for 7 hours now. Jeepers, it feels it as well.
I better hope they never come. Where'd Dennis and Tim go? That's a problem. We don't know what the two of them went.
Oh,
Oh, shit, yeah. They're probably the car sitting down, maybe.
Yeah.
okay. So, like I said, this is
Dennis is telling Timmer it's gonna
Dylan's
be
channel.
okay.
Yeah,
Just
yeah,
hit
yeah.
that.
Patting him
Oh,
on the head.
Oh,
have you
that's
seen
joined. I'm already
J Mac
subscribed.
at all? She's down there somewhere.
And I've
Is she
joined on
down
my
here? I haven't
personal.
seen her yet.
But anyway,
Yeah,
so this
she's
is
down
the
there.
alternate
Oh,
corner,
all right.
and
She's probably on the corner again.
they are doing a dual live stream with Resistant to Silence. So this is Dylan right here, and he's at Wales. He was in Massachusetts, I think, for about 5 weeks, and so he had a really good time. And I had a chance to meet him while I was there. And then there's the fan, because they are, also waiting here. And this is Tracy from Resistant to Silence. And let's go to their channel. And you're going to see the exact same thing, because, like I said, they're doing a duel. And it's really smart how they're doing it is, and it's resistant, not resistance. I don't know why it has that on there. But anyway, so again, you're going to see the exact same thing.
If this goes in,
Tracy is there right now, and that is Dedham, right next to the courthouse. And then Dylan is running the his channel through this, and it's neat because the Resistant to Silence folks, they take turns sharing their stream right there, and so you get to you're there like the whole day through watching them. And that's how I've got to know a lot of who these people were. So when I went, I already felt like I knew them. And then I even got to meet some more people. So it was awesome. And I plan on going back in October to visit them. And so I can't wait, because these people, I'm telling you, they are fantastic. I have never met such honest, good people in a long time. And it really brought my sense of that we still have humanity, because I haven't felt it in a long time. I haven't felt us come together as a country in a long time until I went there. I guess since 9/11. And those that were around that time that can remember, you know what I'm talking about. Everybody came together. Nobody was ashamed to wear an American flag or have a flag outside their house. Nobody thought that because you posted a flag meant you were for the current president. It was none of that bull crap. You were true Americans, and it was just a really good feeling that I had never felt before in my life. And I got to experience that, even though it was from a tragedy, it brought us all together. And then this, I feel like, has brought a lot of people together, not just in our country, but there are other people outside of the country watching, like Australia and Ireland and South Africa. It's amazing. Not only, I mean, are they just watching it because, I mean, in some countries and even in some states, like here in Alabama, they don't video or stream the court, the trials. They, like, we can't view it. If we go, we would have to like visibly drive, which I'm going to work on getting that changed here in Alabama, not only because times are changing with technology, but to keep things transparent in our court systems and in actual court as it's happening in real time. And for those that are disabled and cannot physically be there to watch a trial that may, I don't know, they might want to learn something from it, or maybe they have family that trial pertains to them, but they can't physically be there, but they want to be there and see what happens. They don't want to hear about it on the news or secondhand from someone else. So I am going to, when this is over, this is going to be one of my little side projects that I'm going to work on, is to take things that I have learned from the Karen Reed trial and from Norfolk County and Dedham that I want applied here, whether it was good or bad. There are good things going on in Dedham. Don't get me wrong. There are good things going on in Norfolk, but there are also bad things. And I want to take the pros and cons that I've learned from there and apply it here in Alabama the best I can. I mean, I can't be everywhere. I can't do anything. That's hard when you have the heart that you want to help people and you don't know where to start. You don't know where, you get overwhelmed. But this was a really good, Karen's a really good person that I've related to. And I saw so much that could be learned from this. And that's why I chose to follow it. And little did I know it would just, I don't know, become part of my life. But anyways, we've got to make our courts transparent. We've got to hold judges accountable. We've got to hold the Commonwealth, the states. We've got to hold them accountable, and there's got to be change. Change doesn't come overnight. You have to have a plan. You have to have certain groups of people and personalities working together. And that's what's going on in Karen Reed's case. You've got your loud people and people that like Aiden Carney. If it had not been for him, who's also known as Turtle Boy, if it had not been for him, I wouldn't have known anything about this case. Nothing, nada. And a lot of people don't like him, and I can understand why. But sometimes, just like in a movie you really want to watch, but you're not, foul language, dirty stuff, adult stuff, content bothers you. But sometimes if you really are into what that movie is trying to tell you or what kind of story they're trying to bring across, you kind of put that to the side, you ignore it, and you listen and watch the main points. And that's kind of what I do with Turtle Boy. Now, I do laugh at some of his stuff because I do find it funny. But like the things are a little bit over the top, I either ignore it and stick with it and, while he's telling whatever news he's trying to tell, or I turn it off and I watch later because I know I can fast forward through those parts to get to the main story. But just give him a chance because, like I said, none of this, we wouldn't know anything about it had it not been for him. But again, you got to have your different kind of people, your loud people like him, your people that are organized. They're having standouts through Massachusetts all over and they're organized like every week. They go on Tuesdays. I don't know. I'm just saying this, like to the dive bar, to the pizza place, nacho night. We're having a fundraiser tonight, and it's very well organized. And people show up. It's not always the same people, um, but it's a great idea to get what you're wanting to say out and get people's attentions. And the thing I love about like this, like they'll have like a huge benefit fundraiser for Karen's defense fund. And yeah, the tickets can be expensive, but then they'll have smaller get-togethers where you don't have to spend as much, but if you still want to contribute to the defense fund, that's great. And then of course you can just donate straight to the defense fund, and it doesn't even matter if it's $1. It really, just any little bit helps because the state of Massachusetts has literally drained Karen Reed's funds dry. When I first was getting into this case, and I was having to go to the physical therapist because I had, I think it was, I don't know if it was for my ankle or my vestibular, whatever the case. I went in there and I had on one of my free Karen Reed shirts, and this lady was sitting there, and I swear if I could have rewound that little moment in time, or if I could see her again, oh, I would have so much more to say, but I think I was just flabbergasted. But I was talking to my physical therapist, and he was asking about my, free, who's Karen Reed, what's that? Well, she pops in, not that she was even invited into our conversation, and says, Karen Reed, isn't she that rich lady? Well, first of all, how do you know? You don't even live in Massachusetts. How do you know she's rich? Who did you hear that from? And you know what? To live in Massachusetts, you got to have money because their cost of living is higher. Everything's higher in Massachusetts than like Alabama. I can attest to that. So, anyways, but if I had it to do over to tell that lady, I would have to tell her she's not rich. Is she richer than us? Well, she was, but she's had to sell her home. She never got her vehicle back from the police. She's not allowed to drive. Let's see here. Her attorneys I think they did a cap with her as far as money, and then moving forward they did pro bono, but she still had to pay for experts, the travel expenses and food and everything for those experts. These filings, where you and appeals that she's done, those if you have filed anything at the court, okay, let me tell you, if you've done anything in the courthouse, you should know nothing is free. You have to pay for your driver's license, tags, I don't know, stuff about the house, whatever. Everything costs, okay? So when they're typing up these motions and they're filing them, there are filing fees. I don't know what they are there and how much per, so don't ask me that because I don't know. But everything costs. And let's not forget, Karen had 2 jobs. Okay. She lost them because of this. So she has no income. She only has the support of her family and those that are, us supporters, us that believe in her. And I don't know. It's a wild ride. Sorry, I had to go off on my little soapbox talk, but yeah, it's just she's not rich, folks. And the clothes that she's wearing for the trial were donated so she could have something different to wear. So yeah, let's not pull the rich route. If you want to talk about rich, go see what the Massachusetts State Police and the Canton police officers make. They make, some of them make 6 figures. Yeah. But you have to live in Massachusetts. Um, I looked at houses because I really wouldn't mind moving up to Boston or the Boston area surrounding, and it's crazy. And I'm like, nope, can't afford that. I'll just go visit them. But no, I really have fell in love with the place. And let's see here. I'm going to check Twitter right quick and see. Okay, Aiden. Okay, so and that last question, now that one kind of makes me nervous. Um, I'm looking at Twitter, and Christina Rex had posted. She's a reporter, a local reporter from, I think, WBZ, and she was stating new jury question: if we find not guilty on 2 charges, but can agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? And that is what they were discussing that we were watching. Bev argue, saying, I'm just gonna tell them no, that she can't answer that, and we know that's bull crap. But anyways, okay, let me go back and check and law and crime and see if anything. If not, I may go on lunch break or a nap break or some kind of break. Okay, let's see here. We still have the fan up, which I'm going to go to that screen. Anyways, okay, so in the chat, if and when you come across my stream, just put in there and let me know if you think we are actually going to get a verdict today, and what you think the verdict is going to be. Anyways, all right. Well, I think I'm going to go on break until and I'm going to keep checking back, and so I'll just leave live fan or live fan. I'll leave fan up, and I will check back with y'all hopefully sooner than later. Okay, I'm back and what's going on with my hair because it's so important. Okay. Um, okay, I've been watching my other friends' channels and ate some lunch because I was starving. And so we're waiting. I heard there was some movement, but it is there in Dedham. It is 3:32. So we know Bev likes court over at 4. Except for some reason at one time when they first started deliberating, she said, "Oh, we'll do 5." Okay, and then they what left? Didn't they leave early that day? I don't know. I can't keep up anymore. All the days are closing in. But anyways, let me check Twitter and see what I can see. That's okay. I'm sitting here cussing and talking to myself. Okay, I'm trying to send somebody a link, and then I forget that I'm on the channel. See, that's how ADD works. Mhm. Okay, let me check Twitter. Let's see if anything's going on. Remember, this is I checked there as well. We still have OnlyFans, and we're caught up, so we're not there. Okay, let's see here. Let's see. I'm gonna look and see what Christina Rex with WB's X, I think is what it's called, or Z. WBZ local channel. Uh, okay, don't see anything with her. And let's check Sue's. Nothing. I'm going to check a couple of more. Jess Machado is somebody I follow as well. And of course, Aiden. And so far, not seeing anything. And it is 3:35 there. So I guess we're just waiting and seeing what's going on. Okay. I'm going to look a couple of more places. Bear with me. I still wish I was down there, but I do whatever I can to support. And while we're waiting, if you want to go back, you should be able to go back and see that where I discussed about the verdict form again, and we went over the jury questions, and you got to hear me rant and um, and go on. So let's see here. Okay. Okay. I don't mean to keep pausing that. All right, let me check a couple more places. I'm sorry, y'all. I'm just ready for this to be over. Karen's had enough. We've all had enough. it needs to be done. Okay. Nope. All I'm seeing on Aiden, the last time he reported was about an hour ago. But it is so busy down there. I don't see how anybody is. I mean, it's just flooded with people. Let me try to see if. Let me go back to. Boots on the ground, folks.
Who's that guy?
Always got to be one.
That guy.
Always got to be one.
The
Okay, so everybody is. If you can hear the video,
Now we have the.
everybody's being quiet. So that probably means everybody is returning to court.
Yes. That's
Yes,
Rita.
there's the reads, I think.
How you feeling in this moment, sir?
Okay,
The silence is amazing. It's more powerful than what you people understand. Like that holds power when you can get a group of people
Yes,
like this all together and they all coincide with each other.
and they're all doing the ASL symbol for love. All those people are quiet. This is real time. And that's what Karen has requested that everybody do while they're in the buffer zone because Bev doesn't think we could do that. All right. I'm going to go ahead and jump back over to law and crime while the fan is on, and they should be coming out of that soon. But anyways, again, thanks to the alternate corner and resistant to silence for allowing me to share a bit of boots on the ground live. Because I'm here in Alabama. So, and their channels, I'll list them later in my show notes.
What's the matter?
So what do you think?
I think we might be back tomorrow. I'm live streaming.
Mhm.
Might be back tomorrow.
So
I hope
what
not.
do you think about all of the refinements?
Okay.
Questions.
If you want to in the chat, let me know if you think we're going to have a verdict here at the end of the day, or do you think we are going to come back tomorrow? Just let me know down in the chat. I really want it to be today. But if it doesn't, that's fine because at least this time, again, the jurors seemed to be, not that the others didn't take it seriously, but I feel like, real talk, I feel like these jurors have more common sense than the previous. And they're not letting the four-person just run the show where, like I said before, the previous four-person wouldn't even let the other jurors ask questions. He just kept sitting, we're deadlocked, we're deadlocked, we're deadlocked. And they had questions. So I'm ready for it to be over today. But it's looking like it's not. Maybe they want to take into consideration the questions that they received or that they sent and the answers they got back. And they want to, let's think about it one more night. As much as us that have been going through this with, I feel like Karen and her family, we want this over with. But I'm also I'm torn because I'm appreciative that this group of jurors are taking this into so much into consideration. It's not a rush job, but I also feel like they're getting things done. Um, they're not, I mean, I don't know what they're doing. I'm just assuming, but um, like I said, with the questions, I feel like it's leaning towards what we're hoping for, what the facts led to, what we've known all along. But we'll just have to wait and see. Let's see here. Okay, I'm checking Twitter again. Gosh. Okay. I don't see anything just yet. But I do know they were walking in. So I wonder if they're going to wait on the jurors or I don't know. With Bev, you never know. She says one thing and does something else. Okay. Nothing so far that I can see. Okay. I guess we'll just sit here and wait. Um, okay, why are they showing a dang fan? Brittany messaged me this. They show the fan because they're not allowed to show the jurors. They have to keep the jurors anonymous at this point, as far as when it comes to videos. So it's a joke. It's only fan. They also, that's what you watch. And you can glance at it right quick and know, okay, nothing's going on in the courtroom, but I do see some moving. And that way the camera operator doesn't get in trouble if he shows somebody he's not supposed to or she's not supposed to show. So that's the point of the fan. Um, let's see here. Okay. I think I'm just glancing at your question, um, Brittany, but yeah, if they vote not guilty on those accounts and then on the OUI, yeah, because they could try her again for the OUI. Because I don't think that was on they didn't add that until this verdict slip. But then again, I don't know. The way Bev has been wishy-washy, I'm not even, and I'm not a lawyer, so I have no idea on that part. I'll have to research and see because I'm not going to tell something I don't know. Right. If they vote not guilty for murder and manslaughter, but hang on the other, they cannot retry her due to double jeopardy. That's correct. So, and from what we've heard, we're hoping the questions that they've already realized, okay, she didn't do the murder nor manslaughter, just the OUI. And like I said, I understand why the lawyers did it. It was to give the jurors, those that felt like she needed to be charged with something, just to give John O'Keefe's family some kind of something out of this. And so they did it for those jurors that have another choice besides murder, manslaughter. And they threw the OUI in there, but I don't know if they really thought that through because, on the video clips, Karen said she was drinking and driving. They had the testing done. I wouldn't even say that testing that they did at the hospital could even be credible or count because it was done well after the fact. And we don't know if she had something to drink after she got home. She could have been drinking and calling. I mean, I don't know. So I'm concerned about the OUI. Like I said, it could be up to 2 years, but we'll see. We'll see. We will see. Let me check and see what's going on. Now, I know everybody was in there, so what is taking so long? Let's see here. Okay. But anyways, like I said, I understand where the defense was coming, or this is what I'm saying because, of course, I've not talked to him and I'm not an attorney, but and just based on some others that I've listened to, it's, to give another option to the jurors. And then there's, of course, I've heard that there was a juror that was big about or had been affected by DUI. It could have been a family member. I don't know. Again, these are rumors. And so that person could be very adamant about getting her charged for this. So, okay, it's file. Here we go. Let's see what's going on. Okay, and they're looking at the blinds till the jurors come in.
Court's back in session. You may be seated.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please.
All right, we're going to wait and listen to see if the court has anything to say before they dismiss Karen and the attorneys. Karen's smiling.
Jury's exited the courtroom.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you.
Okay.
Court is adjourned.
Well, that is it for the day. All right. So we don't have a verdict today, but we know they are on their way to getting closer to a verdict. God, I was really hoping it was going to be today. Really hoping it was going to. But again, I can appreciate that they are taking this very seriously. They are asking questions like you should. I feel like this group is great at communicating. So I've got chills talking about it. So I feel like we've got a good jury and that we are going to get, it's going to be good. The ending, the outcome is going to be good. I'm not going to predict, I'm not going to predict that not guilty on this and blah, blah, blah. And I'm not going to ask that because some of us are just too emotionally tied into this. We're too tired to think about it. And yes, would I love for it to be not guilty across the board? Yes. All three counts, I pray, are not guilty. I don't know if that's going to happen, but I guess we'll wait and see. And hopefully we will get that verdict tomorrow after, I think after those questions that they had today, they turned in 4 questions. And I think they were good questions, meaning they were really thinking. It wasn't something off the wall. I don't think Bev's answers were good, especially the part where she had told them that she couldn't answer one of their questions. And I don't think that was appropriate because that's her job. I mean, she's supposed to be there for them to kind of communicate the law to them, not teach them the law because, well, I won't go there. But anyways, I'm tired. I'm irritated, but I'm getting tired. And everybody's tired. That's all I can say. I appreciate those that have watched and hung in there with me today and yesterday, and it looks like we're going to do it again tomorrow. Say your prayers, please. We all need them. And I guess that's going to be it for today. I don't have anything else to say except I'm just really thankful that we got some validation that we've got a good jury. So let's just hope that we get the outcome that we want for Karen and her family and for all of us supporters and for justice. But anyways, until next time, please be aware of your surroundings, stay safe, and please do the right thing.